Welcome everyone to this webinar titled Fusion Law and the CRPD Compatible or Not. I'm going to start my screen share. Well, maybe before I start the screen share, I'm going to just do a couple of kind of housekeeping things. There's a chat function. There's also the Q&A. I haven't really set a preference for one or the other. So periodically I am going to take questions because it's a long presentation. I've set a couple of hours for this. It's a complicated topic. And I'm going to ask people, attendees, to write in the chat or in the Q&A. I'm not going to turn on people's microphones in this webinar. So please, if you have a question, write it in the chat or in the at the bottom of your screen. If that doesn't work for you for any reason, you'll need to contact me by email after the webinar to ask whatever questions you are having. I'm going to be sharing my screen momentarily, and I'm intending to divide up the presentation into more or less 4 sections. They're not all of equal length, but I'm going to be stopping periodically to check and see if there's any questions. And that's a place that, you know, if you're having questions, you can write them in the chat or in the Q&A, and I'll be checking on them at a few different points in the presentation. So it's a pleasure to see everyone here, and I think with that, I'm going to begin. Okay, so you should all be seeing the slideshow at this point. It says Fusion Laws and CRPD Compatible or Not with my name. That's the title slide. I'm going to do first an outline of the presentation. These are essentially the 4 sections here. Oh, one thing I forgot to mention, we have captioning. So if you would like to see the captioning, I'm just going to pause the, oh, I have to just check to see now what, at the bottom of your screen, you should see CC closed caption, and you need to click on that in order to see the captions if you're not seeing them, okay? You have the option to view the full transcript or to view them on your screen. So please, if you would like to access the captioning, use that option. I'm going to, okay. So an outline of this presentation. First, I'm going to do an overview of the CRPD requirements and the concept of fusion law, and a presentation of this dilemma, because why is it being discussed? Why is it a question whether fusion law is compatible with the CRPD? That may be puzzling to some of us. And so I'm going to give kind of an overview of that first, then take some questions if there's questions on that. Next, I'll deal with the development of fusion law as enacted in Northern Ireland, in the Mental Capacity Act of Northern Ireland, and realizing, and some related writings. Okay. I need to say that my knowledge of UK law is extremely limited. I'm really relying on some of the literature and on what the proponents of this fusion law idea are actually saying in their own writings. Those of you who are actually familiar with legislation or with particular legislative proposals will doubtless have corrections for me on anything that I might say about that. And I welcome you to bring up details of any such laws in the Q&A and in the chat. So then again, we'll have a pause and take questions and answers. Then I'll discuss other challenges to general comment number 1, because as you'll see, fundamentally, my view of what fusion law is doing is they're challenging the committee's interpretation of Article 12 in the general comment. And there are some related challenges that have been made by some of the same proponents of fusion law, like the psychiatrist George Schmuckler, okay, and by others. Then we'll also pause again for to have questions and comments, and then the actual CRPD-compliant reforms of legal capacity that we're starting to see, especially in Latin America, and the relationship between such reforms and the abolition of involuntary commitment and involuntary treatment. Okay, I actually just want to check and make sure that we are recording. We are. Okay, good. Okay, so going to this first section, an overview of CRPD requirements and the fusion law concept. What does the CRPD actually require from states parties? Well, to answer that, where are the relevant norms to be found? Is it simply by reading the text of Article 12? And what do you do if you don't understand anything in the text? Do the general comments, the guidelines, and concluding observations of the Committee on the Rights of Persons with Disabilities form part of the normative standard? Is it obligatory on states to implement what the committee says to them in their concluding observations, or in general comment number 1, the guidelines on Article 14 and other general comments? Is the committee's interpretation of Articles 12 and 14 the correct one? And how do we know? Who decides what the interpretation should be? There are rules for interpretation of treaties in the Vienna Convention on the Law of Treaties. I will discuss that a little bit just because it's something that's raised by, I believe it's the Essex Autonomy Project, in their discussion advocating fusion law. And I dispute their view of the interpretation. I'm actually working on writing my view of the interpretation of Article 12 according to the Vienna Convention on the Law of Treaties, which is something that the CRPD committee did not do in their general comment number one. Or to the extent they did, there are aspects of this that I think could be brought out in a little bit closer way related to the rules in the Vienna Convention. So these are the questions that we have to actually consider when we're asking the question of what does the convention require. As you'll see, I think that we can, I'm going to be taking the committee's interpretation as the normative one, and I think it's justified. The fact that these questions are being raised shows that there's a controversy about the substance, okay? Because we're in a situation where there is a universal treaty and where we have a normative standard being proposed by the treaty body, attempting to say what should be the universal standard rather than having every state decide for themselves. And in fact, we're seeing controversy, not just among states, but among lawyers, law professors, psychiatrists, who are among the professions that have to change their own practices. So what is fusion law? An article by Dawson and Smuckler in 2006 note that it predates the adoption of the CRPD and its normative interpretation by the committee in any sense, because the committee only started to work, the committee was only formed after the entry into force in 2008 and started to do real substantive work more or less in 2010 or even 2011. So the premise of fusion law proposals is that mental health legislation is discriminatory because it maintains a different standard for mental illness compared with physical illness, and involuntary commitment, involuntary treatment is based on risk, the so-called danger standard, danger to self or others. Voluntary commitment and involuntary treatment in mental health should be based on an assessment of mental capacity. As you can see, that is something that can also be applied in the situation of physical illness, where we have people who have a psychiatric history or have an intellectual disability or maybe have been diagnosed with dementia. Someone thinks they ought to have some treatment for diabetes or for a heart condition, and there can be some process by which they're declared incapable, and perhaps a guardian is appointed to make a decision and in effect have a treatment done to the person that is against the person's will. So fusion law wants to apply that same standard to legal capacity. But I mean, to mental health, to the mental health context. But even in that proposal in 2006, they don't even fully stay within their own framework, because they say involuntary treatment should be permitted in the case of criminal offenders in particular to reduce the risk of harming others, even if they quote unquote have capacity. Now, we have to ask, is there any conceivable way any of this is compatible with the CRPD? You know, I don't know, of all of you who are participating, how well you know the CRPD. I'm not sure if I said, for those who may not know it at all, we're talking about the Convention on the Rights of Persons with Disabilities, adopted by the UN in 2006 and entered into force in 2008. As you'll see, I don't believe any of that is compatible, and it should be pretty obvious to those of us who are familiar with it. So as I've really said before, this is the dilemma. Discussing the compatibility of fusion law with the CRPD leads to debate about the normative framework, the interpretation, and whose interpretation matters. If the committee's interpretation is to be considered authoritative as a matter of saying, look, there has to be one authoritative interpretation so that human rights law is actually universal, it's authoritative, that's what we're going to use, that's what we're going to rely on. And in fact, there are many countries in which the committee's interpretation is given that level of weight. There are countries, and then there are countries in which it seems unbelievable that that could be the case, and many in between. So, as one of the drafters of the CRPD, as a human rights defender, as someone who actively contributes to normative development in this area from a civil society space, I speak from within the framework established by the CRPD committee in General Comment 1 on Article 12 and the guidelines on Article 14. Advocates of fusion law dispute this interpretation by the committee and maintain that their proposals are compatible with the interpretation of the CRPD, or even sometimes an interpretation more broadly of international human rights obligations that they will bring in from outside the CRPD that they uphold. So where the respective points of view come from, what might the differences be between myself, on the one hand, along with the CRPD committee, along with DPOs and civil society who fought for the standard that we have in Article 12 and that the committee has articulated in the general comment and guidelines, as opposed to the proponents of fusion law who are, there's a psychiatrist, there's a philosopher, there's a few lawyers. None of them are people, to my knowledge, who have ever been subjected to any of these human rights violations. And in some cases, particularly for psychiatrists, having a substantial professional impact, these norms would have a substantial impact on the ways that their profession practices and the privileges that their profession has come to take for granted. So the CRPD norms, I'm going to just run through what Article 12 requires. What are the key points from, this is just a summary that gets in the general comments. So number one, so Article 12 provides for legal capacity on an equal basis with others in all aspects of life, the access to support and safeguards to prevent abuse. According to the committee, this has to include the capacity to act, to make decisions for oneself, to engage in legal transactions for oneself, as well as the capacity to be a holder of rights and duties. Actual or perceived mental capacity cannot justify restriction or removal of legal capacity. Respect for decisions is required at all times, including in crisis situations. That's very significant because this is an area where in mental health legislation, it's one of the situations in which involuntary commitment and involuntary treatment are being implemented. There's a right to refuse support. So support is distinguished from substitute decision-making by the fact that it must respect the person's autonomy, will, and preferences in all matters. There's an obligation to completely eliminate substitute decision-making, and states cannot maintain substitute decision-making, substitution of the person's will alongside supported decision-making. I'm going to discuss later about this corrigendum to paragraph 27 of the general comment, which clarifies that it's any one of three factors that is indicative of substitute decision-making. So it can be taking away a person's legal capacity, even in respect of a single decision, allowing another person to be a substitute decision maker against a person's will, or having a substitute decision maker make decisions based on the person's best interest rather than their own will and preferences. We'll get into that a little bit later, because one of the proponents of fusion law is actually relying on the old version of paragraph 27, which has been corrected. Okay, and the general comment also says that forced treatment regimes under mental health legislation that is a substitute decision-making regime because it violates the right to legal capacity. So the general comment all by itself is actually decisive regarding the obligation to abolish and not regulate forced treatment under mental health legislation. The guidelines on Article 14 of the CRPD committee address this in more detail. So Article 14 says that a deprivation of liberty shall in no case be justified by the existence of a disability. As the guidelines on Article 14 mention, the term solely was proposed and rejected by the states in the process of the negotiations. So some states wanted to say the deprivation of liberty shall in no case be justified solely by the existence of a disability. That would have suggested that adding other factors such as need for care and treatment or risk to self or others could actually justify deprivation of liberty based on a disability. And as the committee says in the guidelines, these factors cannot justify impairment-based detention. They're actually saying there's no such factors at all that could ever justify detention that's based on an actual or perceived impairment, which would include any detention that's based on a so-called mental health condition or a diagnosis of such a condition. And they addressed that in the concluding observations to Spain, where Spain was claiming that their mental health legislation was not in contradiction with Article 14, because they said it didn't apply to people with psychosocial disabilities, only to people with mental health conditions. And the committee said, no, you can't do that. We're talking about all people who are considered to have a mental health condition, and any such detention is against Article 14. So they also say involuntary commitment contravenes the right to exercise legal capacity and free and informed consent regarding hospital admission, care, and treatment. So hospital admission, not only treatment, subject to the person's own free and informed consent, a decision that's part of the exercise of the right to legal capacity. Non-consensual mental health treatment violates Article 14 as well as Article 15, which is the freedom from torture and other ill treatment. They reiterate general comment number 1 on respecting legal capacity in emergency and crisis situations. They also address the penal context, saying that declarations of unfitness to stand trial or unfitness to be held criminally responsible, and the associated forms of detention, including so-called security measures, are contrary to Article 14. They encourage restorative justice and diversion and other kinds of diversion from criminal justice proceedings, so long as such measures do not entail compulsory mental health treatment. So they're really pretty comprehensively closing loopholes in these interpretive materials of Article 12 and Article 14. Two other points, two particular points to highlight. These are from the general comment on Article 12, because I may not get to all of it, but in some of the materials by proponents of fusion law and others in that camp who are trying to justify the continuation of involuntary commitment and involuntary treatment, notwithstanding the committee's interpretations and the convention, will attempt to put a spin on this notion of best interpretation of will and preferences, and also the use of advanced directives as a way to say, well, the committee really is not contemplating the total abolition of coercive measures. And so I want to mention what the committee actually says about this and how I understand it and what the issues are. So the best interpretation of will and preferences, this is actually a very important element that the committee introduced in the general comment to address questions that got raised in the negotiations and in other places. What do you do when a person's in a coma? What do you do in that extreme situation where there's no way it can be possible to determine what a person's will and preferences are and might have to be made? It might be unavoidable to act or not to act. So the committee says that when it's not possible, I'm paraphrasing, when it's not possible to determine a person's will and preferences despite significant efforts, there's an obligation to make the best interpretation of the person's will and preferences and to not utilize a best interest principle. So what that means, and here I'm also thinking of how it's been addressed in the most advanced legal reforms at the national level, utilize evidence of the person's habits, personal history and values, their close friends or family or something they've written in the past, to approximate a best guess as to the person's likely will regarding a particular decision. What we're doing is we're approximating, we're retaining the standard of respect for will and preferences, even in the most extreme situations, by making this best interpretation. And it has to be said, we only do that if it's completely impossible to determine directly what the person's will and preferences are, and non-action or action that anything you do could irrevocably prejudice important rights. So you have to present a possibility of a proposed action accessibly. I would say, this is my take on it. Present to the person, even if the person appears to be in a coma, say, this is what I'm planning to do. I understand this to be the best interpretation of your will. And maybe the person's going to come out of the coma. Maybe they're not in a coma, you only think they are. If the person objects, it's an incorrect interpretation. If they manifest an objection to what it is you're actually proposing, you have to go back and start over again and try to figure out what their will is. And if you can't, then whatever your next best interpretation attempt is going to be. Okay, advanced direct, so it's always about seeking to apply seeking to respect the person's will and preferences to the best and in good faith to the best possible extent that you're doing it in good faith, not some notion of, well, I'm not able to respect your will and preferences because I don't think that it's good for you. That's a best interest determination, which is contrary to the standard. So the committee also, in general comment number 1, includes advance directives to be a form of support in exercising legal capacity. And I think it's not clear from the wording of the general comment, can or should advance directives be used to bind one's own future will? Should I be able to make an advance directive saying, and this is how some people would like to use them in the mental health context, should I be able to make an advance directive saying, if you see me walking out into the street and I'm waving a red flag, okay, just to make it something that is not real, it's just a theoretical. I would like you to understand from that something is going on, that I would like, that in that case, I'm going to authorize you to inject me with Haldol, a neuroleptic drug, against my will, because that's indicative, I'm thinking that that's indicative that I'm experiencing a crisis, a state of psychosis. I don't want to go through it, and I would like you to drug me to stop that from happening. Should I be allowed to do that? Because then, let's say I'm going out waving the flag and you come at me with the injection and I say, no, you can't do that. Force, it's torture. Are you torturing me, or are you carrying out my will? Are you respecting my legal capacity? I think that it should not be done that way. I think it's hugely problematic. My preference is not to enact that possibility into law, and to instead use advance directives as a plan to be carried out subject to my will at a future time. So you can approach me and say, you know, we talked about this. You said that you would like to be injected with Haldol to stop this from happening. How, or do you want to take it, you know, or what do you think? It's a starting point for discussion. Or if I am actually in a coma, now you're not going to give me Haldol in a coma because it's completely irrelevant. No psychiatric measures are relevant if a person's in a coma. So I would even say the best interpretation is something that's irrelevant to the psychiatric context. But let's say I'm in a coma and I've written an advance directive, what I want to have happen. Do I want to have food and nutrition continued or withdrawn? And I'm not communicating. I've written that down, and we could use my advance directive as decisive evidence of a best interpretation if there's no, you know, say, intervening reason to think that I changed my mind about it. Okay, so that's the standard of the CRPD. That's what Fusion Law wants to maintain: involuntary commitment and involuntary treatment based mostly on an incapacity standard. But you'll see that they also, you know, they also don't fully rely only on an incapacity standard. They just want to merge mental capacity and involuntary treatment and involuntary commitment. Is there any possibility that any law could be found compatible with the CRPD that has as its objective the establishment of procedures to authorize involuntary commitment or involuntary treatment in the mental health system. What do you think? If you know the CRPD, the general comment and the guidelines, or from what I have presented. Is there any possibility that any law could be found compatible with the CRPD that utilizes mental capacity assessment to justify the restriction of a person's legal capacity with respect to a particular decision? And as restriction of legal capacity, we can also include failure to respect the person's expressed will. If I say, no, I don't want to be admitted to this hospital, no, I don't want to be drugged with Haldol, that's a restriction of legal capacity with respect to a particular decision, is with the CRPD, based on what you know or what I've presented. So I'm going to check in on what people are saying in the chat to see if there's any questions at this point. I see a lot of greetings, and let's see what we've got. I see someone who is being subjected to forced treatment in the UK. Let's see. I think on issues of a personal situation being subjected to forced treatment, I'd like to get back to you directly to discuss that rather than address it in this webinar. What the things you're saying I don't see as being directly related to what we are discussing, particularly right now. I understand that your situation is important. I want to stay focused on this question of fusion law and how its proponents try to justify it, and how activists and advocates need to understand the intricacies of how this works in order to be able to fight it, in order to be able to stop, to answer what those proponents are saying. Okay, so here is a question from someone who works in the Support Foundation of Girona. Says, although we have had the opportunity to agree, there has been no comment. When the judge forces us to apply treatment and we know how the person does not want it, how should we act? How would you like the institution that supposedly supports you? And they are often protected in their own danger or by others, but we know from the CRPD and report of the Special Rapporteur on Health that it is not correct. It's not always easy to contradict the judgment of a judge. It's necessary before explaining that we appeal to the CRPD. I think you're asking how to explain to the judge as to I'm not sure what the question is. I'm sorry. And Caterina Pedreros, who is a secretary of the CRPD committee, an OHCHR staff person, would like to speak. I'm not sure if I'm able to have you do that. Okay, I see that I can, and I will. I had not intended to open the microphone, but this is an exception because she can speak to from a perspective from the as someone related to the CRPD committee. So go ahead, Katerina. I think you need to unmute yourself, or I need to unmute you. I think you may.
Hello?
Yes, go ahead.
Thank you, Tina. And sorry, I thought you were asking us to speak, to interact. So that's why I raised my hand, my flag. But in any case, I have two ideas in relation to the questions that you posed before, the two questions. If I may share my ideas, I would be happy to do so. Thank you.
If it's just an ordinary question, then perhaps you could write it in the chat, just to keep it in the ways that we have this webinar.
Perfect.
Okay. Okay, so let's see, I see in the Q&A, lawyers, we need standards to seek the will in courts. How? This is a question from a lawyer in Spain, I know, and oh, I think I'll just say I'm answering this question live, which I'm in process of doing. So I think that if you read the materials from Peru and Colombia in particular, you will see the standards that they have put into their legislation, which is the most advanced in terms of compliance with the convention from my perspective, and I believe that many others would agree. There's also a guide for notaries that's put out by a Peruvian notary named Rosalia Mejia, and I would encourage you to read that as well. She's gone pretty far in addressing this from a practical perspective, from a practice perspective as a notary. So that's what I would suggest for that question. Next question in the Q&A that I'm going to answer. How should we interpret the term disabilities of Article 14? Self-perceived, diagnosed, general perceptions, any documents that support a correct interpretation of the term? Well, first of all, the committee is often using the term actual or perceived impairment in relation to the ban on deprivation of liberty in Article 14. The way I understand the term perceived there is not self-perceived, it's perceived by others, because I am one of the people who uses that term, who has advocated that term. Many of us, if we've been diagnosed by psychiatry or essentially accused by someone, say a family member or whomever, as being mentally ill or mad, we may not accept that. We may not consider for ourselves, from our own subjective point of view, that we have a disability. So it's perceived by others, because this question in the mental health context particularly is often a situation where the person really really objects to being viewed as others are perceiving them, and really may reject the whole notion of being a person with a disability, but they're still covered under Article 14. Now, I would say also, especially in the mental health context, and I think many would say in any disability context, if I experience in my subjective point of view that I have an impairment of some kind, that I have difficulties of some kind, and that I'm experiencing barriers in relation to that, I think that should be enough, rather than to consider me a person with an actual disability, rather than requiring some medical diagnosis to actually allow me to access whatever I might need, as well as non-discrimination. So I would say, in a sense, it's all covered, but the question of what does it mean to say actual or perceived disability or actual or perceived impairment, I would say that it's about being perceived as having a disability when you don't feel that you actually have one yourself. Okay, and another question, lawyers have always been told facts can be regulated but not mind thoughts. How can we get new standards? I'm not sure what that is referring to. So maybe you could clarify what you mean. How, I don't understand what it would mean to regulate thoughts, and how are we needing to do that? So I actually see, let me see what the time is. And let me just check. Is there a way for me to check the chat? Okay, is there any test? There's a question in the chat. Is there any test? The standard in mental capacity law, in any law that allows the removal or restriction of legal capacity, the standard is usually something like, does the person understand the nature and consequences of some particular action or some particular decision? Now, the CRPD standard is that there cannot be any test, there cannot be any restrictions of your legal capacity. So you simply have a right to it. So there's no need to prove your legal capacity. If someone is saying you don't have the legal capacity, they're denying you a core human right, and they're violating your human rights. And that's something that it's a question of how to stop that violation from happening. It's not a question of you having to actually prove your legal capacity to them. Okay, I see two more questions about the assessments of legal capacity and deprivation of liberty. This position is contrary to the convention, the human rights model of disability, including and in particular the right to equality and non-discrimination and its relationship with Articles 12 and 14. The committee's jurisprudence has analyzed different legal provisions and practices in state parties that upheld mental capacity assessments, and has expressed concerns and indicated that these are violations of the convention. So that was from Katerina explaining how the committee has addressed this issue of mental capacity, that they are all violations of the convention. So that would say the answer to the question that I posed about whether any such laws could be compatible with the convention on both counts is no, right? The mental capacity assessment is violations And also, I think you're saying as well, the deprivation of liberty based on disability, such as in the mental health context, is also a violation of the convention. Oh, and she continues, an important element is that assessment of impairment as a basis of recognition or emphasizes the medical approach that was superseded by the convention. Please take into consideration a recent article prepared by the former committee member, Ms. Teresia Degener, about how the individual assessments of impairment are depriving persons with disabilities of life-saving measures in the context of COVID-19 crisis. Thank you. Okay, and in this last, in relation to thoughts, follow up from that question, criminal law can't punish the thought of killing, but the fact. So how are we going to regulate the assessment of the will? I think what we're talking about in law, say a notary is always in a position of having someone come in front of them or two parties who want to make an agreement. And the notary has to kind of certify, as far as I understand, that both parties are intending to do this particular legal act. Okay. Now, so this is an assessment that notaries have to make all the time. In a standard previous to the convention, they would incorporate the notion of mental capacity into that. They would be making a mental capacity assessment. Does this person have the capacity to understand the nature and consequences? The notary's job is not eliminated by the convention, but rather it's more, in a sense, simplified. They are making the assessment simply. There's a person standing in front of me. They say they want to do this legal act, say they want to give away their property. Is it this person's intention to give away their property? Is that it? Have they formed the will? Do they have the will? Are they expressing the will to do this legal act? And again, I would recommend the work of Rosalia Mejia, who addresses this, and I believe really Alberto Vasquez in some of his presentations, maybe in some of his writings, might also have done so. I'm going to resume the presentation. Thank you for. Let's see. Okay, so let's look at the Mental Capacity Act of Northern Ireland. Is that where I am now? Yeah, so we're going to discuss the development of fusion law as enacted in Northern Ireland and related writings. Okay, and I have to say, actually, I'm realizing, okay, yeah, okay, so that is. So let's see. Now, I have looked at the law itself, the Mental Capacity Act. I have not studied it in great depth, and I'm relying on this article by Harper et al. And quoting from that article in relation to what they describe of that law. So they say, Part 1 of the Act sets out the key principles which must be complied with, where a determination has to be made as to whether a person lacks capacity, sections 1 sub 2 through 5, and also the principle that where a substitute decision is being made, that it must be in the best interests of the person who lacks capacity, sections 2 and 7. There's also a definition of the meaning of lack of capacity. Lacking capacity, as defined in clauses 3 and 4, is in general the only gateway into the provisions of the Act. Now, from all that we've heard and discussed, what do we know? Whether a person lacks capacity, under the convention, no one can be determined to lack capacity. Particularly if we're talking about adults, all adults have legal capacity. So it's a violation to say that someone lacks this capacity. Also, the principle that where a substitute decision is being made, that it must be in the best interest of the person who lacks capacity. So you're saying that someone lacks legal capacity, lacks the capacity to make a decision for themselves. Therefore, you're going to deny them the right to make that decision and have someone else make that decision for them against the person's will or regardless of the person's will, and that it must be in their best interest. And we also saw that the general comment specifically prohibits the use of this best interest principle in making decisions in relation to an adult person. The best interest principle is still applicable in the case of children. Children are not fully brought within this scheme of simple respect for every decision they make as an exercise of legal capacity. And the CRPD does not fully accomplish that, although there's been discussion about whether it's possible to bring children into a scheme of support and guidance. But I think we've got to leave that aside for the time being. We're talking in this situation about adults. So the best interest decision-making and lack of capacity, that's all contrary to the convention. The exception is when the court makes a public protection order, sections 167 to 173, which is a court power, which does not require a lack of capacity to be present, to detain people who are not culpable for their actions, but cannot be released because they pose a danger to others. So the general comment, the guidelines on Article 14 specifically reject the notion that somebody could be determined to be incapable of being criminally responsible or to be detained pursuant to such a declaration. So I don't think we're talking about someone here who's simply acquitted by a court. The court just says, look, you didn't do the crime, you're not guilty, you're free to go. In this context, they're talking about someone who is essentially being determined that their mental state at the time of the crime was such that they were incapable of being held criminally responsible, okay? Which is contrary to the standard articulated by the committee in the guidelines on Article 14. And it's also this notion of risk, danger to others, which is, it's not clear from what I'm reading, a psychiatric diagnosis or some other kind of disability, actual or perceived, or if it's simply based on this notion of lack of capacity of being held responsible, which is really implicitly the same thing, a disability or impairment standard. So how does the Mental Capacity Act of Northern Ireland address support? Clause 1, sub 4 requires that a person is not to be treated as lacking capacity unless all practical help and support to enable the person to make a decision about the matter have been given without success. This is then amplified by Section 5, supporting to make the decision. supporting person to make decision, which specifies the steps which must be taken. First, let's actually just look at that first sentence. There's a difference between saying there's some way that this looks a little bit like the best interpretation standard, okay? Because the best interpretation says that if you can't figure out what the person's will is, you give them all the necessary support, all necessary accommodations to be able, before you then go ahead and make a best interpretation. But you're still not treating them as, lacking capacity. And the notion that you're treating someone as lacking capacity is really different from a factual situation of simply not being able to know what the person's will is, okay? Because the difference is, if I'm saying to you, Haldol is poison, you better keep that stuff away from me, I'm expressing my will, and there's no way that it could be denied in good faith that I'm expressing my will. I clearly don't want the Haldol. But if you're a psychiatrist and you want to somehow finagle the idea that you should be able to treat me as going to give you all kinds of help and support to enable you to understand, to have the insight into the fact that you have a mental illness and that this Haldol is going to treat you for the mental illness, so you can make a decision. Otherwise, I'm going to treat you as lacking legal capacity and just have my mental health orderlies inject you. That's the difference between treating someone as lacking capacity and the simple notion of providing all needed support and accommodation in order to actually determine the person's will. So, and then they're talking about support which must be provided before a finding of lack of capacity can be made. The CRPD doesn't allow any finding of lack of capacity. And it sees support, and according to this Mental Capacity Act in Northern Ireland, sees support for decision-making as being necessary precisely because a person may lack the mental capacity to make a particular decision. Now that is a little bit, don't quite understand that, because that's kind of the opposite of what it had just said. But there are some people who will treat support as something that you give to a person when they lack the capacity to make a decision. And that's also contrary to the convention. Under the convention, everyone has capacity to make a decision, and a person can use support, but support can never be imposed against the person's will. And I think that the Peruvian law in particular is very clear about that, the Peruvian legislative reform, legal capacity reform. So then again, from the article by Harper et al., they say, unlike the Mental Health Northern Ireland Order of 1986, which conferred powers on substitute decision makers, the Act does not in general do so. Acts of substitute decision makers have the potential to be lawful through the availability of a defense. They are not lawful because they involve the exercise of a legal power. The Act puts the common law Now, I also hope to get to talk about this notion of necessity a little bit later, because there's there are two articles. Well, there's one main article by Piers Gooding and Eleanor Flynn that is trying to argue for the doctrine of necessity as a basis for, essentially an alternative basis for coercive mental health interventions. And then a later article, 2016, I believe, by Eleanor Flynn, where she's arguing that maybe with Anna Arstein Kerslake as well, that not so much forced mental health interventions, but in general, coercive interventions by the state in what really amounts to a best interest principle is something that ought to be enacted. So I may get to that a little bit later, but here they're talking about, they're making the point that anybody could be, in general, in the most general sense, in the most general kinds of substitute decision-making authorized by this act, anyone could go and take action that they believe is in the best interest of somebody whom they believe to lack legal capacity according to all the criteria of the statute. And they're not explicitly given a legal power to do this, but they're given a legal defense. I think that's hugely problematic. And of course, it's contrary to the convention, which prohibits all of these forms of substitute decision-making. Then they also say the basic approach of the act seeks to legislate for a hierarchy of interventions where the more serious the intervention, the more significant the safeguards which must be in place to protect the rights and interests of the person who lacks capacity. Again, lacks capacity is contrary to the convention. For all serious interventions, the required safeguards are a formal assessment of capacity, the involvement of the nominated person, which is, I believe, someone that the person, him or her, may also could be in some situations, someone who is nominated even as in the absence of the person having designated them, and for certain interventions, a second opinion. So here we're getting more into forced treatment, restraint, other kinds of issues, and they want a formal assessment of capacity, which again, assessments of capacity and any restriction or coercion based on such assessments is clearly contrary to the convention, as is any deprivation of liberty based on such assessments, or based on the notion of risk to oneself or others when it's linked with some kind of a alleged disability or impairment, or the alleged decision-making incapacity. Okay. Now, I would say actually that the notion of risk to oneself is always going to be contrary to the premise that we don't make best interest determinations about adults. Okay, because risk to oneself, I'm entitled to take risks for myself. And irrespective of someone else's view of whether that's good or bad for me. So I think there are certain situations that are ordinary in everyday life that, you know, if I see someone about to run out into the street and they're not aware that a car is coming, I'm going to pull them back. And that, you know, I think we can agree that does not involve any kind of a judgment about their decision-making abilities. It's also a very immediate thing, and it's general. We're not really talking about anything that particularly is going to restrict a person's restrict a person's autonomy. So, but I think in general, when we're talking, not in general, I think when we're talking about best interest determinations made about a particular person and saying, because I think also if I pull you away from the cars, I'm not exactly overriding your will. I'm any case, we can work out how that needs to be articulated. But what we're talking about is when with danger to self decisions, saying that a person is risking their safety or risking their health, and therefore some other person gets to come into their lives and intervene against their will on that basis is a best interest determination about adults contrary to the convention. And what you need to do instead is something like, if you're concerned, have a conversation with them. They might tell you to go away, or they might welcome your concern, and it's up to that person. You know, because maybe you're not the one they want to talk to. Maybe you don't have the skills to be able to talk with someone in a way that that's going to actually make them feel welcomed and supported. So again, with the Mental Capacity Act of Northern Ireland, Part 9 from Harper et al., Part 9 retains powers for police officers to remove a person from a public place to a place of safety where the person appears to be in immediate need of care or control. The idea that a person's in need of control is a little bit odd. And either of these, in relation to the notion of capacity, is going to be contrary to the convention. The conditions for the police powers are now that the person is unable to make the relevant decision about going to a place of safety. It would be in their best interest. Failure to do so would create a risk of serious harm, and removal is a proportionate response. So here we have unable to make the decision. That's again, contrary to Article 12, contrary to the general comment to say someone is unable to make a decision, because you're not talking about their own experience. You're not talking about somebody who's indecisive. Gee, I don't know what I should do. If they're indecisive, you can help them if they're open to having help. We're talking about they're deciding they don't want to respect your refusal to go to some place that they think is going to be safer for you. Best interest determination, the notion of risk to self or perhaps to others. And here they're introducing this proportionate response, but it doesn't matter how proportionate it is. We're talking about, you know, what are we talking about? We're talking about someone who's in public and the police want to remove them from public space, which is, I would say, if it's not a police issue, if the person is not, say, you know, engaging in violence towards others, if it's just that, you know, we're not talking about an actual crime being committed here. We're not talking about, we're talking about extra powers being given to the police that are really designed to address people with disabilities, people with one or another kind of disability. So, review for CRPD compatibility. and this is again from Harper et al., and my comments are in parentheses. So when it became clear in the course of the work that they were doing to elaborate this Mental Capacity Act of Northern Ireland, that it was incompatible with the standard elaborated in the general comment, well, they found there were great difficulties with the committee's interpretation. Okay, you know, that's the strategy. That's a strategy that states and members of the legal community and psychiatrists and whoever else will use when they don't agree. They don't like the result, okay? Then they say the Northern Ireland Act doesn't only apply to people with disabilities, therefore the CRPD isn't the only human rights standard available. Well, the thing is, in general comment number 1, the committee is essentially saying that any person lacks the capacity to make a decision or lacks mental capacity amounts to disability-based discrimination. And they don't, I understand it as being we're not ever in these situations really talking about anybody who would not be understood as a person with some kind of disability, whether it's intellectual disability, psychosocial, cognitive disability. That's what we're really talking about. And whether they would consider a temporary disability or more long-term disability. And what the committee is really saying is that this notion of being incapable of making a decision because someone believes your decision-making skills aren't good enough is really in the same realm as any kind of determination based explicitly on disability about legal capacity, and therefore all of it is contradictory to Article 12. So you can't get out of the standards of Article 12 by saying, well, it doesn't only apply to people with disabilities. And I think when we're looking at legal capacity reforms, especially the most advanced ones, we'll see that this is pretty much accepted. And even in some that aren't so advanced, you, like I would say the one in Brazil, you see elimination or partial elimination of this criterion of discernment, which is essentially a functional capacity standard. Then they say Article 12 of the CRPD has to be set in the broader context of jurisprudence of other treaties. Well, you know, that's like saying that the specific expertise of everyone who negotiated the convention and of the CRPD committee and all of civil society that works specifically on these issues is worth nothing. And that instead the law prior to this treaty actually has to be given more weight. That's just a rejection of the specific expertise of people with disabilities and of the disability perspective. And a rejection of the actual binding obligations of the CRPD in preference of some other treaties that are less specific, country-specific legislation and later in time legislation prevails. Then they want to say the use of the terms reaffirm and recognize in Article 12, paragraph 1 and 2, respectively, demonstrates the absence of a paradigm shift. Now that's really interesting to me because in the negotiations, we explicitly discussed that paragraph 1 of Article 12 discusses, paragraph 1 reaffirms the basic right to recognition as a person before the law that is a right, as a right of people with disabilities. And the term reaffirm was used very deliberately there because it was believed that that particular right is so basic to be recognized as a person before the law, and it does exist in other treaties, that to say anything other than reaffirm would suggest that it hadn't been previously recognized that people with disabilities had a right to be recognized as persons before the law. So reaffirm was used there very deliberately. Paragraph 2 uses recognize equally deliberately. Recognize is the term used in human rights law when you are, for the first time, actually bringing something into human rights law as a new recognition. Okay, so human rights law, there's the principle, there's the idea in human rights law that human rights are inherent to every person, that they can't be created, they can't be taken away. And so then how do you deal with that when you are in the process, when you're becoming aware that something is a human right, or a human right of a particular group of people that you hadn't actually understood before in previous legislation? So the formula used is to say we recognize it. So it's actually the opposite of, it actually demonstrates that there is an intent to make a paradigm shift, contrary to what they're saying. Then they also say states parties consistently reject the committee's interpretation. That was untrue even in 2016, because in the monitoring committee that is in charge of the regional convention that deals with discrimination against people with disabilities, it's actually a body of representatives of the state's parties. And they issued a general observation. I can't recall what year, but I believe it was before the CRPD committee's general comment, that was already recognizing the essential outlines of the paradigm shift in a very decisive way, and saying that their own treaty had to be interpreted to reject a provision on that had legitimized interdiction or legal incapacitation. And it's even less true today. We have the reforms in Peru, Colombia, Costa Rica, and other places where states are really beginning to put this into practice. And even in the Council of Europe, where the European Parliament is, I believe, has called for, and I think they're doing, carrying out studies about non-coercive practices in mental health, because they don't want to, there's a huge amount of opposition to the draft Oviedo Protocol, which would codify at the European level provisions legitimizing involuntary commitment and involuntary treatment. I'm going to skip that one because we really don't have lots of time. The Essex Autonomy Project, interesting group. Wayne Martin, a philosopher, is part of it, and also Adrian Ward, a lawyer, both of whom, when I have encountered them in conferences, have been pretty consistently opposing the standard of the CRPD and the CRPD committee. So looking at their 3 jurisdictions report, they say they're taking general comment number 1 into account, but they're not bound by it. UK didn't agree to be bound by the UN committee's interpretation. So if you're in the UK and you want to oppose this view of it, you know, you can talk about the politics, you can talk about what it means to have a universal human rights treaty and a universal standard without without the interpretation of the committee. But technically, it's correct to say that states that these interpretations are not binding in the same, they're not binding, they're not binding in the sense of international law. So you can, so it's really more a matter of persuasion, a matter of discussing the nature of human rights and the reasons for one paradigm versus the other, you know, and questioning the basis for what these groups are saying. They want, so Essex Autonomy Project want to make their own interpretation of Article 12, which I think is actually very weak and can be opposed. Referring back to their own report from 2014, they disputed the meaning of the phrase respect for rights, will, and preferences in Article 12, paragraph 4. They took paragraph 4 out of context. They weren't addressing it in the context of Article 12 as a whole or of the convention as a whole, which is, that's what they are actually required to do by the Vienna Convention on the Law of Treaties. So they're actually taking terms out of context, not applying the full context that they need to, and not addressing the object and purpose of the convention, including the principles in Article 3. They also invoke the travaux préparatoires, essentially the negotiating history, which that can be done under Article 32 of the Vienna Convention to resolve ambiguity or avoid an absurd or unreasonable result. But you can only do that after making an actual, after attempting a basic interpretation based on the plain meaning of the terms in their context. So I think that Essex Project is essentially, they acknowledge that, but they do that Article 12 neither prohibits nor endorses substitute decision-making. The thing is, and the committee faced this in its elaboration of general comment number 1, if it's not decisive, even if it's not decisive, whether Article 12 neither prohibits nor endorses, there has to be something done when you're in the process of reforming national law. You have to either eliminate substitute decision-making or maintain it, and maintaining it is the same as the old paradigm. So the committee did conclude that we have to eliminate all substitute decision-making regimes. And they rely on that paragraph of general comment number 1 in its original form, that was later superseded. So this is the correction. This is the correction saying that the defining features of substitute decision-making regimes, legal capacity is removed, even in respect of a single decision. A substitute decision maker can be appointed against a person's will or by someone other than the person concerned, or any decision made by a substitute decision maker is based on best interest as opposed to the person's will and preferences. In the original version, that or read and that would have suggested that all 3 factors had to be present in order to characterize a regime as substitute decision-making, which would have been problematic, and that's why I would assume the correction was issued. So just note that, that Essex Project in this 2016 report was relying on that earlier version of paragraph 27 in some of their arguments. So let's go to questions again. Let's see, that one is done. Okay, I think this is the same as before about how should we act when the judge forces us to apply treatment and we know the person does not want it. I mean, I think it's contradictory to the convention to force treatment when the person doesn't want it. And if you are supporting me, I think that you have to say no to the judge. If you're not legally allowed to say no to the judge, then you actually are not a supporter in that instance. It's contradictory to force treatment on a person, and there's really nothing that can be done to make that okay. So it's really actually problematic for someone who is holding themselves out as a supporter. And I know that your organization is trying to move from the guardianship institution to being support all the time. But I think that, I would say that you have to fight the judge's order if you're on the side of the person, appeal it. Do you have lawyers working with your organization? Appeal these orders, appeal it up as high as you can, get the funding to appeal these decisions. And if you don't get the right judgment, take it under the optional protocol to the CRPD committee. So that's what I would suggest. Question, would it be possible to analyze the case of a person very depressed who decides to suicide? Should doctors respect his or her decision anyway? I would say for suicide, I do see suicide as being a decision that people make. It's often actually a decision that people make over the course of a long period of time. I think it's a very unhappy decision. But I do see it as a decision. I don't think it should be up to a doctor to say that they're not going to respect it. What I see as being useful, and there's a few different organizations in the US that I know of that work this way, providing support for people who are suicidal, providing a non-judgmental space to come and talk about it, of peer support. It's usually people who have experienced this all themselves who participate in these kind of usually group discussions about talking about suicide. And people come there and they can trust it. They can trust that you're not going to report them. You're not going to bring the police, which might kill them. You're not going to bring psychiatry, which might put them in restraints, inject them with Haldol and all of that. So that's the way I'd want to approach it, that in order to support people who are feeling suicidal, it's about supporting the person and, not focusing on this question of whether they actually do commit suicide, whether, this notion that I have to stop them from doing this. rather, what can I do to support this human being who is in so much pain? So that's the way I would like to approach suicide. And I hear someone saying the Essex Project is now looking at insight. Yeah, it will be very interesting to see what they come up with, because I would guess that's going to be their next iteration of how they would like to try and justify the continuation of involuntary treatment and involuntary commitment. As the next part of my presentation is dealing with similar things. Let's see, because it looks like there's more that I guess these are all the ones I have answered. Is there anything in the chat that, anything else in the chat? Okay. So let's go back again to the presentation. Okay. And I'll try to get through these next parts quickly. I may just do the rest of it all at once, not have another pause. So other challenges to general comment 1. So some of these are very related to the so-called, he's pretty ubiquitous at a lot of conferences. He was, you'll remember, one of the original proponents of that fusion law paper in the UK in 2006. This is one recent paper of his that I found that was open access, capacity, best interests, and will and preferences in relation to the convention. And I've heard him present on this over the past couple of years also. He's promoting this notion that since the CRPD discusses will and also preferences, they must mean something different, and that somehow you can split will and preferences and in a way that allows the psychiatrist particularly to make decisions, substitute decisions for the person, okay? So my summary of what he's saying in that paper, he sees the will as incorporating discernment, as incorporating some kind of process of deliberation or reasoning and persisting over time. And he also thinks it's capable of being assessed for others as to whether something that you express as your will is coherent with your longstanding values. So his agenda there is to say that when somebody is in a state of psychosis, what they're expressing is not coherent with their longstanding values, and you don't, or if it's not coherent with what someone, psychiatrist, perhaps a family member, believes to be the person's longstanding values, then it's not really the will in the sense meant by the convention, and therefore you don't have to respect it. And he says essentially that your preferences, which are temporary, as he understands it, don't necessarily have to be respected. And that's a little bit ridiculous, because the convention says, and the general comment says, you have to respect both will and preferences, even if his notion was correct, but it's essentially a functional capacity standard, so doesn't make it. Paul Skowron wants to reinterpret the best interpretation of will and preferences as, well, you know, of the best one, you know, the most outstanding, best interpretation, not the most accurate, which most desirable, which is essentially, he wants to reinterpret it as a best interest standard. No, you can't do it. the two of them also raise red herrings of inaccuracy in interpretation. Yeah, inaccuracy in interpretation happens, but the point is to make the best effort possible to do it and keep checking in with the person about what your interpretation is, and actually listen and pay attention to what they may be trying to communicate with you and respect it. Undue influence of supporters and the notion of rights as conflicting with other rights or with the person's will and preferences. And this is something we see also, we see in other papers. I think this was in the Lancet paper that was opposing the general comment, and is in the standard expressed by the Subcommittee on the Prevention of Torture, which is the treaty body for the optional protocol to the Convention Against Torture, which deals with visits to places of detention. And this notion is that, well, that the right to health could conflict with the right to autonomy or legal capacity in particular. And the thing is, the human rights regime in general, it's a regime of respect for each individual human being, the dignity, the equal worth and dignity of every individual human being. It's not a regime that is directing states to deal with rights in some abstract sense and make judgments about how and when rights might conflict with each other. It's a regime of human beings making demands on their states based on rights that are viewed as inherent. So you cannot split the person up and then say somebody else delegated by the state or designating themselves is in a position to judge which right, how different rights may be includes the principle of free and informed consent. It's not in contradiction with it. So that's just, it's a very paternalistic, elitist view. And from some of the material cited by some of these writers, you know, we're really talking about very privileged, elite European understandings of the will that many women, many people in poverty, and people who are oppressed in any way worldwide can simply end up finding it impossible to see themselves in that way of looking at the world, okay, including people with disabilities. So the German court decision, this is actually, I've understood, I've been led to understand by German lawyers, is a feature of German law. The same notion that there's a kind of more rarefied will that is to be respected, that's based on deliberation and reason, more or less. And there's your natural will, which is just what I feel like doing in any particular moment. So they distinguish between free will and natural will. Some quotes from the decision associated with free will is the ability to recognize the necessity of medical measures or to be able to act according to this and to be able to act. So they were saying that a person who lacks free will cannot recognize the necessity of medical measures or cannot act according to this realization. It's a functional capacity standard, contrary to the general comment. It's determined on the basis of indications, especially drawing on earlier statements or given the quality of the expressed natural will. So you know, I don't know if George got his ideas from the German court, or where he was drawing that notion from, his distinction between will and preferences. It's certainly very similar to what the German Constitutional Court had said. And it's they acknowledge that they were rejecting general comment number 1, and what the possibilities are for getting the German court to change its views. But I think it's certainly a pity if people with disabilities in Germany are subjected to that standard. And I think, again, like, this is how is the CRPD committee resolved those questions? It's, as I said, what they're doing, what those writers are doing is advancing a functional capacity standard. The committee has decisively rejected it. So again, are we talking about a standard that, we're talking about a standard that rejects the committee's interpretation of Article 12. So we're talking about a dispute about the interpretation. Who is correct? How do we understand it? As I said, I'm working on writing out a rationale for an interpretation of Article 12 according to plain meaning, in context, in light of the object and purpose, etc. But with which I am hoping to support the committee's interpretation in general comment number 1. There could be other kinds of work done of that nature. Okay, we are getting close to the time, so I'm going to skip. I think what I'm actually going to do, I'm going to skip some of those slides. I'll make the slides available to everyone, and you can ask me questions. I'm just going to talk about the CRPD compliant reforms in Latin America and how they relate to the abolition of involuntary commitment and forced treatment, because the proponents of fusion law actually, you know, I don't want to give them credit for anything, but I think what has led some people to find the idea appealing is the insight that legal capacity is somehow linked with the question of involuntary commitment and involuntary treatment and mental health. So what does it mean for involuntary commitment and treatment when you have a reform of legal capacity, with which I would say Peru pretty clearly does, and Colombia, I think, does also, in the way that, you know, I feel my sense with Colombia's law, you have to look a little more deeply into it, but that it substantially does, and that Costa Rica has achieved pretty much through its implementing regulations. Okay, these reforms have the potential to require the total abolition of involuntary commitment and involuntary treatment. Now, in some other countries, the context may be a little different in terms of viewing involuntary commitment particularly as an exercise of the so-called police power, and you're going to have to bring in Article 14 as well. You might not be able to do it all through Article 12, but remember, it's actually paragraph 10 in the guidelines on Article 14 that says decisions about a hospital admission are decisions that amount to an exercise of legal capacity. So that hospital admission should not be in any way a form of control of a person. Okay. So Colombia's reform actually included the abolition of some of the legislative provisions for involuntary commitment and involuntary treatment, and contains a residual clause that generally derogates all other provisions inconsistent with the reform, so that lawyers in Colombia could pursue that, could find all of the provisions in the law that would allow still involuntary commitment or treatment and challenge them constitutionally on that basis. Peru had already substantially modified its mental health legislation. Advocates are, and they have very small, very short-term duration of emergency involuntary commitment and treatment in their legislation now, and it's something that really has to be done away with in order to make it complete, to complete the paradigm shift and the full guarantee of human rights, and need to address involuntary commitment in the penal law context as well. I would hope future reforms at the national level will include from the outset the abolition of all involuntary commitment and involuntary treatment in the mental health context as core provisions. Conclusion. So as I said, the linkage between legal capacity and involuntary commitment and treatment is recognized. That's a common ground between DPOs and the CRPD committee and the proponents of fusion law. The difference, I would say, is the aim pursued by, the two separate groupings and the understanding of autonomy. The aim of fusion law is to reform involuntary commitment and involuntary treatment, but to keep it in place. They don't want to do away with it. And they take legal capacity as conditional. They don't see it as universal. They see it as something that a person might have or not have. The CRPD aims to abolish involuntary commitment and involuntary treatment and takes legal capacity as a universal right. The fusion law approach to autonomy is paternalistic, elitist, colonialist, and patriarchal, in addition to being ableist. They see it as a condition of self-actualization viewed as individual capability. They see autonomy not as something that's inherent to the person that has to be respected by others, but as a condition that a person might achieve or not achieve, and that can be somehow assessed objectively by others. And then who is in a position to assess that? Who's going to set them up? Who's going to set themselves up to assess the self-actualization, the achievement of some kind of state of being that you think is autonomy by another person? It's a very elitist view, and I think it's contrary to human rights in general. The CRPD approach is respect for the freedom of all persons with disabilities to make choices and independence of persons. I like to think of the incommensurability of persons, that there's a divide between me as a separate human being and you as a separate human being. We can get close to one another, but there's something about me that you can never know, and there's something about you that I can never know, and there's something about you that I can never. Forbearance, not doing something, restraining yourself from doing something in relation to another person when you just think, damn it, I know that's going to be bad for you, but you can, like if it's not this thing of running out into the street, right? You have to really respect that this is another human being and they're evolving in time just as you are, and their needs, you cannot totally understand what their needs are and what they're relating to. So you exercise that forbearance in solidarity and with any needed support and accommodations. And now it's really getting close to the schedule end. I don't know if the captioner is well, maybe if the captioner is willing or able to stay longer, maybe I can just try to finish. What magic word should we use to combat CRPD practices? I don't think there is a magic word. I think it's really a question of developing understanding and just doing everything that we can. Are there more questions? Do people want to stay? Because I think we may have just come to an end. I would, be open to having people ask me questions. I think you probably all know how to reach me. I'm very available. Facebook and even Twitter and my various pages and emails, the CRUST website, and I'll put that information when I upload this recording to YouTube. So I think since there's no more questions, I think I will close and thank everybody for attending this webinar. Really great questions, and I appreciate everyone's being with me today. So thank you. Okay.